So if you can take your seats, we'll get started. Welcome to our oil and gas and mineral law continuing legal education seminar. We thought about changing the name to the practice of wind damming semis. We felt that maybe it was more of a niche even than oil and gas is. So our first speaker this morning is Bob Townsend. He's the administrator of the Minerals and Mining Program for the South Dakota Department of Environment and Natural Resources, and that's a position he's held since 1988. Bob is a registered professional geologist, and in his capacity as the administrator with DENR, he's responsible for oil and gas, for the regulation of oil and gas exploration and production. And one of the things that South Dakota is doing is going through, and it's an ongoing process of updating and modernizing all of our statutes and rules related to oil and gas. And in his capacity as the administrator, Bob is a leader in that project. So, Bob, welcome.
As you can see, what I want to talk to you about a little bit this morning is oil and gas rules and permitting. But before I do that, what I'd like to do is give you a few facts to kind of put things in context. I'm sure most of you realize that South Dakota does produce oil, but you may not know where and how long that's been going on. Oil was first discovered by Shell Oil Company in Hardin County in 1953. We've been producing oil ever since. We have about 150 oil wells in the state of South Dakota. Most of them are in Hardin County. We have about 15 producing wells down in Fall River and Custer counties. We have about 100 producing gas wells. Those are all in Hardin County. Our total production over the last 3 or 4 years has been right at about 1.6 million barrels per year. That's about how much North Dakota produces in 2 to 3 days. In terms of gas production, it's not very much, although the number sounds big, it's not. About 1 billion cubic feet per year. The productive formation in South Dakota in terms of oil is the Red River B formation, B as in boy. It occurs at depths of about 8,500 feet in Hardin County, and essentially 95% of our production comes from that formation. The small amount of production that comes from Fall River and Custer counties comes from what's called the Middle-Lucid formation. That's at a depth of about 3,000 feet below the surface. One other thing, Max kind of gave you an overview of what we do, and of course our responsibility is to implement the state laws and rules that apply to not only oil and gas but mining, but today I'm talking about oil and gas. We do that through a permitting, inspection, and enforcement process. We do that in conjunction with the South Dakota Board of Minerals and Environment. In fact, we have 2 former board members here in the audience today, Tom Grassley back there, and Bill Taylor, who was over there, are both in the audience. The board's function primarily is to hear contested permits, and they also have the authority to promulgate rules. So that's the body that we go before to have our rules approved, and that's what I'm going to be talking about primarily this morning. So I'll go ahead and get started. A little bit about the presentation I'm about to give you. This is the same presentation that I gave to a special interim legislative committee that is currently conducting a study of the oil and gas statutes in the state of South Dakota. They've met 3 or 4 times so far this year, and they They have their final meeting in here this month on the 30th to go through some potential legislation that they may consider. And I will talk a little bit about that at the end of my presentation. Now to get started, the oil and gas conservation rules are comprised of 10 different chapters that apply to various things that relate to oil and gas exploration and development. There are chapters on drilling, on operations, on abandonment and plugging. There are statutes on unitization, record keeping and inspections. One of our administrative processes is governed by a rule that's called the Notice of Recommendation process. And finally, there's a chapter on risk compensation, and that has to do with forced pooling and compulsory unitization. And I'll talk a little bit about those things later on. The basic authority for the rules is in the statute, which is SDCL 45-9, and that's called the Oil and Gas Conservation Act, or statute. Now, one of the things that we were challenged to do about a year and a half ago by the governor was to look at all our rules and statutes and so forth and review them for adequacy, whether or not there is unnecessary red tape, are there things that we can do to streamline them, and so forth. So about a year and a half ago, we undertook the task of going through all of our rules to see what we could do to streamline them, update them, and make them easier to comply with the goal of fewer, shorter, and simpler regulatory requirements. In addition to that, the last time we did this, it was almost 15 years ago in 1996. A little bit about the process, and I'm not going to go on this. Again, about a year ago, we went to the Board of Minerals and Environment with a package of essentially new rules, although it contained many of the old rules. They held a public hearing, we had public testimony and so forth. They adopted the rules as we recommended. Those rules then went to the interim legislative rules review committee in December. Those rules were approved by that committee, and then they became provisionally effective in January, and then finally effective in July. One of the major things that we accomplished through this rule process was to eliminate some clutter that occurred in the existing rules. There were about 11 pages of previously repealed and transferred rules that basically made a mess of the printed rules and made it hard to find things. So what we did is we recommended that the board repeal the old rules and adopt a new chapter. And effectively what that does is it takes away all of those old repealed and transferred rules. That makes the format of the rules much more user-friendly. Some of the streamlining efforts that we undertook included combining a number of rules that lent themselves to that. We eliminated a number of rules that were redundant or simply not needed, antiquated. And one of the key things that we did was to look at approval processes and the time it took to get through those. And we revised some of the rules related to the time frame for approval to shorten the approval process. Here on the next 2 slides are just examples of some of the things that we did. And I'm not going to go through those. You have those in your packet if you're interested. Now a little bit about some of the things that we've done in the recent past to promote oil and gas development in the state of South Dakota, rules and statutes. Back in 2004, the industry came to us and told us, hey, we're looking at doing some work across the border between South Dakota and North Dakota and Hardin County, and it sure would make life easier if you could adjust your statutes in regard to the ratification percentage for units and risk compensation so that they mirror North Dakota's. So we took that to heart, we took that to the legislature approved that, and our ratification percentage now is the same as North Dakota's. Our risk compensation rules are also similar now to North Dakota's. The the ratification percentage previously was 75%. 75% of the working interest owners and 75% of the royalty owners previously had to approve a unit before it could become functional. That percentage now is 60%. A couple of other things that we did. We adopted new rules that encourage shale and gas exploration in 2008. And then again in 2011, streamlining of the rules that I'm talking about here. And then another significant thing that we did was we introduced House Bill 1012 during the last legislative session. What that does, basically, is it only requires hearings on oil and gas matters if they're contested. Now, what we did was we went back and we looked at the number of hearings that the board had on oil and gas matters over the last 5 years. Turns out only 3 of those were contested. So from here on out, as of July 1st, only those cases that are contested will require hearing. That will reduce the load on the board and staff, and so far it's working. We've actually had 2 or 3 cases go through that process. Okay, the next series of topics that I'm going to talk about are some of the oil and gas permitting subjects that we deal with on a daily basis. See, I've listed there drilling permits, well construction, well plugging, well spacing, unitization, underground injection control, permit processing procedures, and then I have a little discussion on hydraulic fracturing, since that seems to be in the news these days. One topic that I did not include in this talk is the concept of pooling, enforced pooling and risk compensation. That's a fairly complicated procedure. We just went through a hearing Wednesday that involved those topics. And I can certainly answer any questions that someone might have on those topics, but I don't intend to talk about that as part of this presentation. Okay, a little bit on drilling permits. There's an entire chapter in the rules about drilling and drilling permits. Anyone that wants to drill a well in the state of South Dakota has to obtain a permit from our department. It's basically a one-page application. Here's an example of an application for a permit to drill. It's for a horizontal well in Hardin County. I believe the operator was Continental Resources. Continental is one of our larger operators. They've been in the state since the mid-90s. They operate 3 what we call fire floods, or secondary recovery units that use air injection up in Hardin County. But this is an example of a drilling permit application. It has particulars on the operation, the depth that they want to drill to, the cementing and casing plan, and so forth. Now, other requirements that apply to drilling permits, there's a $100 application fee. There's a bonding requirement. There are 2 bonds that can be required. The first is called the plugging and performance bond. That's $5,000 per well, or $20,000 statewide. That's set by statute. There's another bond that can be required in cases of split estate, and that's called the surface restoration bond. That's $2,000 per well, or $10,000 blanket. Now, other requirements include plats, surveys, general plans for the drilling site. There's a requirement that the applicant submit a form that certifies that he's negotiated with the surface owner for damages. The applicable statute there, or the chapter, is SDCL 45-5A. That's our surface damages statute. We don't get involved in those negotiations, but we do require certification that the operator is dealing with the surface owner in good faith. Here's a typical producing oil well in Hardin County. You'll see, I didn't notice this when I picked the photo, but no, that's not oil pooling in the middle of that drill pad. It actually does rain in Hardin County, and it's rainwater. To the right is the pump jack. That's a pump that pumps the oil up from the producing formation. In the middle there are actually 2 pieces of equipment. There's a heater treater and an oil water separator. Typically, the oil is produced with some water. It's brackish water. It has to be separated. And and then it's put into tanks. One of those tanks is probably a water tank, and the others are oil storage tanks. Now, drilling permits are issued administratively by our department. We target issuance in 14 days. There are no public hearings. They're not public noticed. We apply conditions to each permit related to things like plugging, casing, cementing, final reclamation, and so forth. And in terms of horizontal drilling, and virtually all the wells drilled in Hardin County now are horizontal wells, they have to provide information on the way they intend to construct the well and the coordinates of the casing. Now a little bit on well construction, and I have a couple of diagrams that will follow here, but well construction is one of the most important things that we deal with because this is what protects our groundwater resources. The first thing that an operator does when he starts drilling a well is he'll drill a relatively shallow hole and install surface casing. And casing is basically steel pipe. In Hardin County, the typical depth that we try to cover includes the near-surface aquifers that are used as domestic sources of water. And those include primarily shallow alluvium or colluvium, Fox Hills Formation, which is a sandstone body, and then sometimes the Hell Creek. In Hardin County, those range anywhere in depth from about 200 to 500 feet. And then the operator typically installs 1,500 to 2,000 feet of surface casing. The surface casing then is cemented from bottom to top, so that the entire casing is covered by cement so that it's protective of those near surface aquifers. Once the surface casing is installed and the cement's allowed to set up, they'll continue on drilling down to the target, which in this case in Hardin County is the Red River B formation at 8,000 to 9,000 feet. After testing, the decision is made whether or not to produce the well. If this decision is not to produce the well, the operator will proceed with plugging. If they intend to produce the well, then they install production casing. That again is cemented in various locations to protect water resources. Here's a diagram. On the left are some of the geologic formations through which holes are drilled in Hardin County. You can see on the upper left, there are 3 small wells indicated. Those are the typical shallow wells that are used for domestic purposes. Contrast that with the next well, which goes down to the Red River at 8,000 to 9,000 feet. You can see the casing, the cementing, and so forth there. Put my glasses on so I can see. Again, this is a typical horizontal well in Hardin County. Now, again, speaking of horizontal wells, if it is a horizontal well, what they do is they have a special tool that they take down the casing, and they mill a window in that casing just above the producing formation of Red River. And that tool allows them to make a curve into the producing formation, and then they can drill out up to 10,000 feet in some cases in North Dakota. In South Dakota, it's primarily 5,000 to 6,000 feet. So we're drilling down to the Red River Formation. The Red River Formation itself is only 10 to 20 feet thick. And in addition to that, the real target is a 2.5 foot thick section of porosity. So they're drilling down 9,000 feet and then out perhaps 5,000 to 6,000 feet in a 2.5 foot thick layer of rock. It's pretty amazing in my mind. Now, the horizontal component of a well is called a lateral. Generally speaking, in Hardin County, the laterals run without casing. In other words, there's no pipe in the hole. It's not needed to maintain integrity. The rock's competent enough that it won't cave and so forth. This is a little cartoon of what a horizontal well looks like. There are several different types. The types that we use primarily in Hardin County with two on the right. There's a short radius and a medium radius horizontal well. Next topic, well plugging. This is the other thing that we do to protect water resources. Once a well is either produced and abandoned, or it's never produced, it has to be plugged in accordance with our rules. And the purpose is to protect groundwater resources by confining fluids to the geologic units in which they originally occurred. If the well is plugged without production casing, there are specific plugs that have to be set over given formations that have the potential to be used as a freshwater resource. In Hardin County, the major aquifer of concern is called the Indian Cara, although our industry folks call it the Dakota. It's not really the Dakota. And in terms of specific plugs, you can see there are various plugs that have to be required. I'm not going to go into that in any great detail. The message, though, is that cement plugs are required to protect groundwater. And this is the same schematic. On the right is a typical well again in Hardin County. And it shows the various plugs that are required by rule. Occasionally, we'll require additional plugs, especially across the Indian Cara. Now, the next topic I'm going to talk about is well spacing. In terms of the Board of Minerals and Environment, and where we see the most activity in terms of legal representation is in the area of well spacing, pooling, and unitization. So, in terms of attorney and practicing and so forth, this is one of the main areas. Now, well spacing basically defines the area in which a well can be drilled. In addition to that, there are things called setbacks. Once the area has been defined, and it usually coincides with a governmental, like a 40-acre tract or a 160-acre tract or 640 acres, something like that. Once that's established, then a setback is required. The setback establishes the distance from the boundary of that unit which a well can be drilled in. It basically outlines a window within the spacing unit. The purpose of spacing primarily is to promote orderly development, promotes, I don't know if some of you have seen some of the oil wells in the early 1900s in the area called Spindletop in Texas, but there were wells stacked one right on top of the other. And there was a lot of waste oil and gas at that time, and actually out of instances like that arose a model statute and model rules. And this actually, in our rules, and most states' rules and statutes, had their inception at that time. Another of the things that spacing addresses is correlative rights, protection of correlative rights. And I like to think of that in terms of not draining your neighbor's oil. It's more complicated than that, but that's the way I think of it. It also prevents the drilling of unnecessary wells. Now, in terms of ownership, all of the mineral owners in a spacing unit share the production on a pro rata basis or some agreed upon formula. We do have statewide spacing established in rule, and that's for a well that might be drilled where there is no production. It's called a Wildcat well. Spacing for oil wells is 40 acres per well with setbacks of 500 feet. And then for gas wells, it's 640 acres with setbacks of 1,000 feet. Now, spacing can be applied for. That's typically what's done when an operator makes a discovery. They want to drill an offset. By rule, they have to apply for and get a spacing order from the Board of Minerals and Environment. The spacing unit, or the field, if it's made up of more than one unit, has to be defined by the operator using geologic and other technical information. Proposed pattern has to be established. One of the key things is the spacing unit may not be smaller than the area that can be drained by one well. Again, the spacing unit is designed for orderly development and making sure that you're not draining your neighbor's oil. In terms of fields that we have in South Dakota, they range in terms of spacing anywhere from 10 to 1,280 acres. We have 28 oil fields and 3 gas fields in the state of South Dakota. Again, most of those are in Hardin County. We do have a few in Fall River and Custer counties. This is an example of a field up on the South Dakota, North Dakota border that was established just a few years ago. The reason I show this one is that it's relatively new, but it also establishes some of the typical spacing that you'll see up in North Dakota.